This is Robert J. Colassa, attorney and CPA in Lake Forest, Illinois. For the next few minutes, I'm going to talk about some common estate planning mistakes which I see clients commit in my practice from time to time. These mistakes are avoidable. Number one, assets passing outside a will or trust. I see this a lot. Clients have a living trust, for example, and they believe, rightly or wrongly, that all their assets are subject to the dispositive terms of that trust. Well, that may not be true if all the assets are not in the trust. In particular, assets with beneficiary designations or held in joint tenancy generally are not subject to the terms of the living trust. I'll give you an example. I had a client, second marriage, had $2 million worth of assets, and his intent was, and in fact this was parodied in his living trust, upon his death half the assets would go to his wife, his new wife, and half to the children of his first marriage. Beautiful plan, right? But I had to tell him upon review of his documents and how he held his assets, Mr. Client, your spouse is going to get 75% of the assets. How could that be, he says. Look at my trust. It provides for a 50-50 split. It did. But what was missed was that the $1 million IRA named his spouse as beneficiary, thereby defeating the dispositive scheme of a 50-50 split. In summary, just because you have a living trust doesn't mean the assets will be subject to the terms of that trust if they are not in the living trust. In a separate video, we will have a segment on trust funding, which is very important. Improper use of joint tenancy accounts can be an estate planning mistake. I see this many times with my single senior clients who perhaps need a little help in their financial affairs, and they designate the caretaker child as joint tenancy of some or many of their accounts. And that all works out beautifully during the client's lifetime. However, a consequence of joint tenancy is upon the death of the first joint tenant, the property is owned 100% by the remaining joint tenant. That means in those cases where the child is the joint tenancy holder with the client, that upon the client's death, all the money is legally vested in the child's name. Now that may not always be the client's intention, who has a trust or will where the money is to be divided equally among the remaining children. But guess what happens? Many times the surviving tenant, the child, does not want to throw that money in the pot and takes a position which is legally correct, that it's all my money. Substantial assets in joint tenancy can substantially impair the client's intent in distributing assets in an equal fashion to family members. Improper beneficiary designations. Now we've talked about this a little bit. It's really critical in evaluating your estate plan that you make careful effort to determine who the correct beneficiaries of your insurance policies and your retirement benefits are. This determination should be carefully coordinated with the terms of your living trust or will to avoid unexpected results. Because the beneficiary designation is named in the designation will trump out the terms of a will or a trust. This is a good one. Having the wrong executor or trustee administer your estate plan can be a fundamental estate planning mistake. I've seen many well thought out and carefully devised plans ruined by the inadvertent or negligent actions of trustees or executors, keeping all the securities in the market during a recession where 40% of the market value is lost, or executors or trustees who simply do not perform their underlying tax obligations. Having the wrong captain of the ship can sometimes sink the ship and cause dire results. Think carefully in choosing the appropriate executors, trustees, and agents in your estate plan. Procrastination, very common estate planning mistake. Why spend the effort to devise a trust or a will right now? We can do that next year when you retire, or maybe when your daughter gets married. Unfortunately, non-action will adopt an estate plan which may not actually meet your objectives. Please, spend some effort, put some muscle into developing an estate plan, which is consistent with your desires, your goals, and the particular needs of your family members. It will be worth it.